IP rights overview. And it's a kind of a standard package that is supposed to give you an overview of what intellectual properties are, give this view through practical aspects, do some little exercises, and cover following topics. In short, we will today start with the introduction, which will explain the relation between intellectual property rights and intangible assets. Then we have we start going into the specifics, and there is copyright and industrial property, the main division of intellectual property rights. Then we go into trademark, industrial design related rights, which is a bunch of rights that are not strictly intellectual property, but are used in business to protect intangible assets. We will look at patent into somewhat greater detail as one of the most important rights, which confers the greatest exclusivity to the holders. We will look at business secrets and confidentiality that are basically unprotected inventions and innovations that are kept secret and protected by secrecy. Then there is we will look a little bit about the transfer of rights, which means the licensing contracts. We will look at counterfeiting and piracy and infringements in general, and connected to contractual disputes. We will look into dispute resolution about these rights, meaning when you have the right, what happens? You license them, someone infringes them, and then you try to resolve these disputes. So this is what is ahead of us in these 3 days. And without further ado, I will launch into the first group of topics, which is this introduction where we will look at the relation between the rights and assets. And in order to properly understand this, we need to look at law and business context of these both rights and assets. We will, because of what I presumed and what I have learned about your project, I have decided that patent law will be looked to somewhat greater detail, and we will look all the innovation aspects of general project activity. We will look specifically into how you grow a portfolio of rights. Obviously, this is not necessarily part of the project. It might be part of some kind of a spin-off of some kind of a commercial activity associated with any project. And connected to that, once you have a portfolio, then you need an IP strategy, because from experience, we all know that unless we have a strategy, it is very difficult to efficiently manage the rights. In other words, if you don't have strategy, if you do things as you go, if you rely on ad hoc decisions, you will spend more money on your IP protection, and you will spend much more energy, either scientific or entrepreneurial energy of the participants. So we need to build a portfolio, and then we need to have a strategy of how to manage it. And we will, in light of that, we will look all of the rights that we will present here. We will try to see them from this point of building intangible assets portfolio, and then the IPR portfolio, and the strategy of building and managing it. So when we talk about the IP law, I work a lot with scientists, and I have seen very often that people speak about those IP rights. They refer, when they say IP, they say that IP. They don't specify most often, or they say some IP rights or things like that. So it's not from this, and when you then go deeper, then you realize that many people actually are not fully aware of what constitutes intellectual property. What is the elements of the added value that they themselves might have developed and added to the original, to the state of things before the project started. And that this added value will, in modern scientific and economic activity, very often be protectable as intellectual property. Not all of it will be protectable as intellectual property. There will be many things that might be somewhat difficult to capture with the rights that are offered to us as possible protection. There are different forms of knowledge that are not squarely fitting within the 19th century, and I will talk more about that, because that's what it is. We use a system for protecting intellectual property that was devised in 19th century, and our activities today and even our creativity today is different than it used to be in 19th century, and therefore the legal system sometimes is challenging, and the things that people develop might not, as I said, squarely fit within the boxes predetermined by the IP system of so-called Paris and Berne conventions. These are these 19th century instruments. And there's nothing wrong with Paris and Berne conventions. They were signed in Paris and Berne respectively, and Paris Convention protects industrial property rights, and the other group, the authors' rights and the related rights, are protected by Berne Convention. So there's nothing wrong with it. And these two international, as we lawyers say, multilateral international treaties were among some of the most successful in the history of mankind. And they have like 150, 160 member states, member countries who have joined over this century and almost century and a half. We are not there yet, but almost. So they joined, and the intellectual property rights is to a great degree more harmonized, or at least it was harmonized earlier than the other fields of law because of this success. So this is what we need to understand in general about the history. And as I said, we were speaking about the industrial property and authors' rights, and I will explain a little bit more further on today why this traditional division really does not make that much sense anymore. And our economy today is based on industrial activity in such areas that were traditionally not considered industrial property. And think not only about entertainment industry that in the 40s and the 50s became a significant industry, adding a big proportion to some countries' GDP. Think only about Hollywood, that certainly is a huge industry. But later on, software industry that is using copyright, that means authors' rights, because copyright is a common law term for authors' rights. So the software industry, since the mid-60s, early 70s, became the biggest industry in the world, and is not using what is traditionally called industrial property rights, or it's using it but to a much smaller degree. So you see that how our civilization quickly, in the span of a century, really stretched the pre-existing concepts and made them somewhat less useful than we would hope that they are today. So we must be flexible, the users, we must be flexible, adjust to this older structure and use it to our advantage. And there is one other element. Not only creativity was different, but our markets were somewhat different. Although at the 19th century, IP rights started because of the global trade. So industrial revolution caused an unprecedented level of global trade. This is still nothing compared to the globalization that we have today based on digitalization. Once we established digital domain and the global network of computers, which we refer to as internet, once we had internet, the territoriality came under huge pressure, and our markets changed from national jurisdictions, and this is important because IPRs were based on national jurisdiction. So nowadays, the national jurisdiction is becoming a burden, and if you will, very literally, EU itself is a reaction to the fragmentation of national jurisdiction, which are just unpractical. And even before digital domain, we started realizing that we need a common market. And then we understood that this must be further improved. And still today we are struggling, for instance, with the service directive, because the services are not regulated on the common market. They are still tied to the national regulation and things like that. So we are behind our needs. And intellectual property, unfortunately, this is quite painfully evident. And so don't lose patience with IP once you start using it. Because IP, because of its complexity, is relatively slow and expensive. The advice, because of the complexity, is expensive. So many people in Croatia, I have to say especially, and you need to know that I have studied and worked in the US, but I have worked in Italy for quite a number of years as a lawyer, as a foreign counsel in Milan, and I know how things look on the ground, but can confidently say that in Croatia there is especially some kind of resistance to using IP, because our universities have this idea that knowledge needs to be shared, and our scientists very often are always step behind. Not all, you know, there are some very entrepreneurial scientists. I'm sure each one of you will know one, you know, at least. But generally, there is some kind of a resistance of using IP, and we need to be aware of that and start deploying all this, what we will talk over the 3 days earlier. So let's look in the IP in the business context and how it works in developed markets. And as I said, we have this traditional division to industrial property and authors' rights that we will follow just for here purposes of systematization, but which I said does not make much sense anymore. The question is, the question really is, why do we protect IPRs? What is the advantage of having this complex system? Well, here you see something that is at the same time both ancient and very modern. You know, let's just think about the Italian port of Gioia Tauro, for instance. You know, I'm sure it was there 3,000 years ago, you know, but the ships that were sailing in were not in this shape, and there were no containers. And in the containers, there were no complex goods. 3,000 years ago, every human manufacturer, engineer, knew, or at least was able to know, all the knowledge in the world. That is, all the knowledge in the world was possible to be known and understood by a single individual. Since 19th century, we started making so complex products. There's no single individual that can understand all the aspects of a single product. Take just a computer mouse, you know. There was this famous comparison of mouse with the stone knife developed by Australian Aborigines. And they have almost the same shape, that stone knife, which had a round end and the sharpened end, you know, on each side. Looks just like a mouse, and it's shaped to the size of the palm of the hand, just as humans did not change that much. But our knowledge and our science and our invention became so complex that today no one can, as an individual, reproduce, the mouse. We don't know how to make plastics. We don't know how to forge this aluminum that is on the lower side. We don't know how to do this laser tracing camera or whatever it is. I don't even know what it is exactly, you know, in the mouse. Yet it is just a human product as the other one. And that is what has changed. This huge amount of knowledge. We started in 18th century. In the 18th century, we had first modern laws of intellectual property. Many of you, especially in Italy, might have heard about the protection of intellectual property in Venice in 15th century. Where there were some kind of the privileges. The Republic, La Serenissima, was giving the privileges, for instance, to a German, Giovanni Spira, who brought the printing press. But this was still not what we consider a modern IP. The modern IP started some 150, 200 years later, in 1709 in the UK, with a copyright law called Statute of Anne. This was not a privilege. This was available to any publisher at that time who was printing a book. And from that moment on, we have a curious coincidence of incredible increase of human wealth and use of intellectual property. So there might be some connection, and actually it is possible that human capability to perceive the intangible and the value of intangible was what caused this incredible increase in social wealth, which has no comparison in history of mankind. So we really benefited from using intellectual property, and we continue to do so. And I can tell you, as someone who is 30 years doing intellectual property, that I am quite confident that IP will change, as it was never in the past. It will change much more, but it will continue increasing for a time being. Therefore, we shouldn't be wasting our opportunities to protect it to our benefit and to the benefit of our societies. Before I leave this slide that connects us, you know, the Adriatic Sea, I am speaking to you from an island in the Adriatic Sea. I am on Brač or Bratza. Here, and these boats are passing some 50 miles beside me in the central Adriatic between our two countries. But why I picked this, not because of Adriatic and because of the you know, common link that it is because of trade. Trade is older than this mouse. It is old as that sharpened stone that Aborigines used in Australia 16,000 years ago. So trade is what is defining for human race. By doing these exchanges, we do it, and these containers are symbols, not for the goods inside, for the element of trade only, but also for intellectual property, because you can bet that not a single container on this picture and on the other boats ahead and behind of this vessel that is shown here are loaded with intellectual property. You know, these goods might have 10 patents on them. Each little mouse in there will have a number of patents. And when they come to our ports, this is in the US, obviously, but then we try even to enforce these rights. And here you see, talking about the Aborigines, Australian Customs Service with an older X-ray scanner trying to see what is inside. Because this scanner cannot detect intellectual property, but it can detect the goods, and then we check which goods did the scanner detect really the goods that contain intellectual property. We check them and we stop them if they are unlawfully traded, and that's more or less the whole story. You see, that's how it looks when you look at a car with the X-ray scanner, and then you can zoom in and you can see, you know, which components are there. Does it look like a genuine car? Is it like a genuine, things like that. So it is abundantly clear to all of us that knowledge is the driving force behind the modern economy. We have this creative and innovation capacity that we have as humans, as individuals. When we organize in economic activity, in companies, essentially, then this becomes the main lever of competition in modern context. This thing, you know, again, we are Europeans, and we do our best to do good in the world. We try to have a modern economy, a lot of inventions to stay ahead of the others. But we have all the time pressures from all the sides. You know, there are those who are infringing the rights. Think only about, I don't know, Turkey or Morocco, for instance. A lot of goods in Italy that are counterfeits come from Morocco. To us, some of those more than Morocco comes from Turkey. But we all have China, you know, as a big source of good. Although, you know, this is not anymore the situation in which China is exporting infringing goods. China today has more scientifically based innovations than Europe. Are they as relevant or not? I don't know. You will know better. But it's not the idea in which China is copying us. It's just the opposite in a way. You know, they are in some ways, certainly in investing in research, China is ahead of Europe, you know, in absolute terms. So this happened already 10 years ago, and still we think, you know, that they are only copying. You know? So we have this situation where all societies, at least developed ones, are using this added value. We add value, and this added value is something that we are trying to protect. That's what we try to determine whether it is or it is not intellectual property rights. And you all know that modern companies will most often have the IPR portfolio, the value of their IP portfolio, higher than their real assets, real estate and other assets that are material. So this enables us growth. It enables the way in which we place product on the markets, this is really the behavior of the companies, and this is also was very visible until recently in Croatia. Now, since Croatia joined European Union, this difference is disappearing. But before, Croatian companies didn't really know how to use IP, and in that way, you saw a big difference on how they were doing business. Croatian companies were, in a way, for 20 years, they remained transitional economy. And only more or less approximately the time that when we joined the European Union, plus when the European funds became available to the companies, and all the project competition needs to have an IP component, did Croatian companies start using intellectual property in the same way as the other European, their competitors. Now we are on the same market, no? So their competitors on the same market were using, and now Croatia stops being a transitional economy and is rapidly, this pandemic year was absolutely stunning. Many of you know that Croatia during the pandemic year produced its two first unicorn companies that are valued above $1 billion. So we went from a transitional economy to one of the fastest moving and most dynamic economies in the EU within a year. This is hard to comprehend, and most of Croatians don't understand this. They still look with pity at themselves instead of joining this big wave in turning things around. But that is the power of modern economy and intangible assets. I will not go into what are these two companies that became unicorns do. One is software, the other is automotive and battery electric cars technology. But these are the most competitive tech fields in the world. So obviously, as part of the European economy, Croatia started, being somewhat more important than it was before. And you see, you develop things differently when you have new technology, when you take account about the technology that you are adding as added value on the existing situation. How you commercialize innovative products will be different than when you don't have innovative products. How will you increase the financial resources? For instance, this is in Croatia still not on the level of developed European economies, because our banks don't take intangible or IPRs that protect intangibles as collateral. So unlike in Italy, where you can apply, I was involved with a Regione Veneto project, which was in Croatia. I don't know if any one of you was. It was called Evlija. It was Bicro Hamag and Regione Veneto and Ca Foscari. I don't know who else was involved. And it was about really expressing value of intangibles so that the banks can extend loans to the companies that would have them. And that was for sure 10 years ago, and not much has changed in Croatia. So we have a lot of work to do, but that is unavoidable because that is part of this new economy that I'm talking about. So you get new funding opportunities. And, ultimately it's about the image with the consumers, competitors, shareholders, society in general. Are you a relevant company? And in developed markets, it's the company that develops IP that is perceived as a relevant company. And to sum it up in a way, you know, this is something that I'm using to explain to law students, because when you study law, they teach you to pay attention mostly, or I would even say only, to intellectual property. At the law school, you will never learn much about the intangible assets. They will talk about IP only in terms of rights. And how do we conceptualize, especially those of us who are not lawyers, and how do we conceptualize this relation? Well, think about water and the glass, a container for that water, or a wine, which we are both Italians and Croatians are wine countries, very importantly for our identities. So we can think about the wine, you know, and the nice glass that we use to drink wines with, but here in that comparison, the container, the glass or the bottle will be rights. So the rights is what you use to manage the liquid. The liquid, if you don't put it in the glass, it will spill, it might evaporate, you know, it will get impure because it gets in contact with other things. So in order to properly manage the liquid, we need a glass. And that's the intangible and the container, and you know, and the right. The right is the container. So you will be developing as scientists liquid, but don't forget to put it in the glass. Otherwise, it is gone. No, and no one will be, and our societies will not be able to take benefit of this added value that you have extracted. So you see, this is just an illustration from field of trademarks, where you have the value of brands associated with these trademarks based on the evaluation of the portfolio associated with it. And this for last year, the number one was Apple, and followed by Amazon and Microsoft, and then by Google and Samsung. So we had the first 5 being tech companies, and specifically actually 4 being important IT companies, really. Although today it's difficult to divide the two. So who can say that Samsung is not an IT company, or that Amazon is not also a commercial trading company? You know, just a huge warehouse for distribution or whatever, logistics company at the same time. It all is merging, and only then do we have those who were 15 years ago, like Coca-Cola or the car industry, you know, Toyota, Mercedes-Benz, and then followed. Then you would have McDonald's and who knows who were number 1, number 2, number 3. 15 years ago. So that's the fact. And these values, I apologize, this is so small that I can't read it on my screen, but it goes in hundreds of billions of dollars. Hundreds, you know, where when Coca-Cola was biggest with 70 billion 15 years ago, today it might have 90 billion. I don't know, I'm inventing now because I can't read this. But Apple had in 2019 almost 200 billion, and here it might be even with 300 billion valuation. You know, these are just staggering numbers. These numbers are as big as GDP of the large countries and bigger than GDP of most of the smaller countries in the world. You know, So these are just amazing value that is held in intellectual property and intellectual property rights. So when we use them, I think it is abundantly clear from what I have said before, and I can even drop this and allow you some questions at this point. We are 15 minutes before break. So if you want to ask at this point, I think that this is a good point. Are there any questions? And I don't see you on all on my screen because I have first, because of MS Teams, that doesn't show really everyone. Plus, I'm on the laptop, so it's not a huge screen. So let me know, or just speak up, please, if you have questions. Any reactions? No. If not, then let me.
No question for me.
Yes, please.
No question. No question. Thank you.
Okay, thank you. Thank you. So let's look at this, and we will all recognize from this what is happening around us in our economies, which are constantly launching new businesses. We talk about startups. This is speeding up. We are having more and more businesses being launched and more products and services being offered. So we will try then to develop a market identity for those entities, such as a company, for instance, or a product line, or whatever, how we will define the segments of our economic activity. We will use the identity that we will develop when we will be recruiting new employees. They will be more responsive, to something that they will be perceiving as a valuable brand, a brand that is true to its values. This is a most recent trend that we have over the last 5 years, let's say, that companies are becoming very, very socially responsible, that they are pushing their sustainable credentials up, and the things that before were absolutely not part of industrial activity, now they are becoming, because they impact the value of the brand, the value of the identity. And this is a new and very, very important development. While doing all this, we need to be careful of not disclosing what is confidential before we protect it. And we will have a lot of opportunity to destroy the confidentiality, negotiating a joint venture, talking to a bank about a loan, with our subcontractors, with consultants, with employees. We need to develop a shield of confidentiality during all of these activities, all of these interactions. Otherwise, the confidentiality is gone, and we will not have it anymore. And once it's gone, there is no legal protection of confidentiality. So keep that in mind. We will be back to this when we will look at the business secret. When we are developing a new marketing campaign, again, we will use all these elements that we were developed under the first bullets. When we develop our software, our platform for doing businesses, so not only websites, but all of this will create this added value, which might be protected by copyright, which might be protected by database right, or who knows by what, but it has to be identified early so that it can be managed, meaning to be put in a container so that it can be managed. So you have software, you have design being used. Then we have, again, when we go into formal protection of trade secrets, and we will be looking how this is done, then we need to develop our internal bylaws, have a marking rules, control and supervision of these bylaws. So we will look all this in detail. New business cooperation is always a challenge because you want to hide from your, your potential partner who may be your potential competitor or your real competitor. You want to protect some aspects. So you have to thread very carefully in order to not to destroy what can be protectable before it is protected. Then when you have accounting and finance things, you need to do a proper bookkeeping of the value of the assets. And that's very challenging for a startup. So you need to have a proper advisors who will do you a proper structure of accounting so that you can express and keep the value of intangible assets on your balance sheet. When you merge, demerge, all different, when you get acquired, so the famous exit for a startup, this all entails further challenges to your IP portfolio and the ways of managing it, and you need to know how to do that. When you exit, again, you want to think about many aspects, and I'm not going now into this detail, but in short, just by this random set of examples, you actually see that it is always. You need to think about IPRs all the time, from before you start the activity until you exit. And please keep in mind that it's different to think about IPR and know what you have to do, then building a strategy and implementing it. Because as a startup, if you try to go into protection of patents, you are very likely to bankrupt yourself on the patent applications, which might never mature into a patent in the end, because you will just not have money. So before you are a founded startup, just keep asking things about intellectual property, because you will not have money, because unfortunately it is, again, complex and therefore expensive. So you will not get very far if you start protecting, but you need to know what you will protect, and you need to know how much money you will need to protect it. So to ask the investors to protect, to be able to protect it. And so that's one typical problem in the cycle of modern economy. This is more of the same in the way that this is just randomly taken manufacturing on marketing, and then you see which rights might be used. And when you are manufacturing, you must look whether you have some inventions. And if you have inventions, then patent would be in order. If you don't have enough funds to do the full patent until granting, then you will use such a strategy that you will have a patent application pending as long as possible. And if, for instance, you use PCT route, and we will talk about that in detail tomorrow, then you will just try to extend as long as possible the time that application is pending before you pay the fees for the national patent protection, which is the most standard of this is the PCT, which I mentioned, the Patent Cooperation Treaty. You need to understand if you have an invention or you have only a technical improvement, which might not be protectable by patent, but may still represent some kind of a know-how. And then if you have a know-how, you have to know if the know-how is secret or not. Because if it is not secret, you can't make it secret just by declaring it confidential and proprietary to your company. It doesn't work that way. You cannot do that. So it must be factually secret in order to be protected under the business secret rules. Then you need also to know licensing possibilities. You can be licensing in or you can be licensing out, meaning if you are taking the technology and paying for it instead of developing it in-house, or you develop the technology that you don't need, for instance, and you license others to use it. You must be aware of the competition rules, which are not IP at the same time, you know. This is a separate body of law, but you will need lawyers tell you, you know, are you licensing within what is allowed in a given country or in a given region, such as for instance, European Union. When you are doing marketing, you will probably not have a patent, but you will have a trademark which might be protected or unprotected. And in Croatia, we don't have unprotected trademarks. We have signs of trade protected by unfair competition rules. But in Italy, for many years, and I don't know now what's the situation now, but when I was, you know, in the 90s and 2000, there was unprotected trademark, which was very atypical for a civil law country. This is what you have in common law countries. But there was a possibility of acquiring unprotected trademark, and that's this TM here, and R meaning a registered trademark, which is the trademark in proper sense. You will probably have industrial design when you are doing marketing. You will again have not again, please distinguish competition from unfair competition. These are two different bodies of law. Competition law is total. This is what is in the US called antitrust. And competition law is the unfair trading, unfair competition, separate body of law, which is much closer to IP, and we will talk about it there in this bag of mixed rights that I called related. And then again, we will have licensing, and we might have copyright added, and so on. So strategy. Let's finish with this. This is the probably the most important really thing. Once you decide to use, and deciding to use means budgeting it primarily. Because it's so expensive, as I showed on the example of startups who cannot afford it, what actually happens is that when you decide to start using IP protection, you need to have a budget. And then, in order to have this budget used efficiently, you will need a strategy. So this starts with the proper intangible assets identification, and then you manage it through managing the containers, the IPRs. So once you have IPR portfolio, and you know, whoever of us protected a domain name for their business already has an IP portfolio. You have a .hr, .com, .it, you know, you started your IPR portfolio. You have to be aware of that as an entrepreneur, and you have to start building a management strategy for it to continue. Then normally you would add the copyrights that were developed for you, design of the website, you know, whatever is copyrightable, the software, and then you start doing trademarks protection, and then you start looking if there are inventions that are protectable by IP. Obviously, if you are invention heavy, if you are really scientific based and you are not selling to the end consumers, then the order of these steps will be different. But you need to do it, because unless you do it, you will not be structuring and prioritizing efficiently your resources. You have to identify the products, the markets, and then the rights attached to the products that you have, and prioritize them in respect of the rights on the markets. Once you protect and and develop and protect first batch of intangible assets through adding value, that is modern creativity. When I'm saying adding value, this means creativity in modern sense. And this is, once you do it, then you are on the course of being an efficient modern market entity. Okay, let's stop here, have a break, and if you have questions, I can stay here a minute or two, if you want to ask questions now, but otherwise we can start with questions at the beginning of the next block in 10 minutes. Is that okay?
Thank you.
Okay, thanks. See you.
Thank you very much.
Yeah.
Thank you very much.
You're welcome.
Thank you.
Hi.
Hello.
Hello. Are we all back or we are not? I don't see. People don't
You're
have.
very on time.
Yes, trying.
I'm here.
Yes.
Me too.
How many of you, if I can ask, do you have patents yourself? Did you have experience with intellectual property earlier?
Yes, I have one patent from my master thesis. So I went through the process. It has European protection.
I see. And is that a European patent or what kind
Yes,
of?
yeah, European patent. Yes, exactly. Although the faculty paid for it, it's in my name and my professor's name.
I see. Congratulations.
Thank you.
And the others?
No, Roberta Latteri speaking from Venice. I'm not have any experience on this topic, and for me it's the first time.
I see. I hope then this will be useful and kind of help you use the patent system or any other IP. That's.
Hello, excuse me, please.
Yes.
It's Simone Marini speaking, CNR, Institute of Marine Science. We have also an European patent. We obtained this recently in 2020, but the process started in 2013. So we have got a lot of time for obtaining the patent.
Yes, there are many reasons why a patent grant procedure can last long. Sometimes it is because the applicant wants it. This is also part of the strategy, and sometimes because there are some problems with it, and you have to redefine the scope, and the examiners ask you to narrow it down and things like that.
The big problem was the delay between answer and reply to the reviewer. Usually more than 1 year after yes. So we replied the reviewer comment, and they reply maybe 1 year later.
I see.
Yeah. Actually, after this iteration, we reduced a bit the claims, but not in a really relevant way. Just we found an agreement that was really good for us.
I see. Excellent. Congratulations to you as well.
Thank you very much.
Good. And just out of curiosity, I mean, where are you? Some of you or all of you, where are you sitting physically? I mean, also the Croatians. I mean, are you Split, Rovinj, Zagreb, and what about the Italian scientists? Are you in north, south, on the Tyrrhenian? Where are you from, really?
Me, I'm Elena. I'm from Italy. I'm from Treviso. Me and my colleague Sara Toffoletto are joining the meeting today, and we are part of a path lab here in Treviso. Yes. And we provide support to companies in the fields of patents and trademarks.
I see. So you are.
Treviso is very close to Venice, just to give a hint about the geography.
I'm very, very familiar. I can tell you the trattoria where to go to eat. I really know Italy. I lived in Italy for many years. Also, I mean, as a matter of fact, I think I should tell you, I speak at home Italian. My wife's Argentinian. And we met in Italy, and we met in Orvieto and started speaking Italian, and here 25 years after we are.
Incredible.
Yes, so we both love Italy and travel a lot. So these are two countries that for me as home. this.
Okay. Orvieto is known for Orvieto Classico, a wine, I mean.
Yes.
And Treviso is very known for Prosecco wine.
I love wine, and I can, tell you from Gorizia to Aosta, every vineyard. I'm serious about wine. I founded slow food movement in Croatia because I lived between Bra and Alba, and in Provincia di Cuneo. So I met Petrini very early on, and in '96 I have founded slow food in Croatia. So a lot of my time in Italy is connected to enogastronomy. Yes. My wife is a food professional, and in Orvieto we met at the food fair. Good. Okay, let's not take more of your time, and I go back. Do you see the shared screen?
Yes.
Okay. Good. Yeah. Okay. So let's continue where we stopped. And this is what I have mentioned, that there is this traditional division of IPRs, which doesn't make much sense anymore, but you still need to be aware of it in order to be able to properly use the system. No? So we divide IP into copyrights and related rights and industrial property rights. And then we have another batch of what I call, this is not really, I call it related in broader sense, because they protect company name, which is actually belongs to IP, but it's not fully an IP right. And business secret, technical improvements, when you manage it, you need to have a set of rules for managing technical improvements. Then business rationalization, all this what is not patentable. Unfair competition rules, internet domain names that I have mentioned already as belonging to the batch, then labor law, where you have rules of is it employer or employee who will have rights to the invention, then database rights, the other data which is not in the database, which is the new frontier for lawyers really to determine to which regime of protection will data belong to in the future. Personal data, and then privacy regimes where you have other types of intangibles where we are actually claiming some rights on them. And all this is part of this big, deep well of intangible asset legal protection, so to speak. What you all figured out without me, that protection of IPRs requires time, knowledge. It's not something that people without knowledge can successfully do. Therefore, you need to dedicate your employees, train them. You need to develop strategy. You need to budget this. Without all this ancillary steps, you are not going to be successful. And there is just impossible to be successful with an ad hoc approach. Then, yeah, let's move further. And how does this look like when we look a little bit closer? This has different elements, which I will then further break down. So we look, when we manage, then we do strategy, we estimate the cost of this, of the actions that we think we will make to do, and then we need to implement this. In order to do this successfully, one way that many companies are doing it, especially larger companies, to have an IP department. So there's a group of specialists that will have some kind of concentrated, specialized knowledge of managing the rights. Please don't think that IP department is a good place to take account of the strategy. It needs to be the administration of the company, the management of the company, because if you are managing assets, you don't give lawyers or other specialists to manage your asset. So many companies in Europe, especially in Europe, I have to say, because as I lived in the US, I actually came from the US and I worked in Italy first. And I have to tell you that it's a huge, at that time, 25, 30 years ago, it was a huge difference in knowledge of how you do IP. And Italy is traditionally okay, really, with the family brands, you know, the luxury goods, I don't know, the Salumi, you know, there are good, very well managed brands, but not all of this huge strength of the global trade presence of Italy was managed up to the level that you would expect from such a successful company in the US, for instance. And then Croatia was at that time, was beginning, you know, mid-90s, was again much behind in this knowledge of what you have. And one thing that Croatian companies were not doing right is this idea that you give managing IP rights to lawyers. That's not the right way. You have to give it to the management of the company, to its administration. There must be an IP portfolio, otherwise things are scattered and invisible. Then you have to take care about the employees. You will have your local laws. You know, every country will have its own set of laws that might be giving different scope of rights to employer in respect of employee. So somewhere, employer will have more rights, but it doesn't mean that in another country there will be the same amount of rights given to the employer, and the employee might be in a better position. Then you need to have soft laws within the company, such as bylaws or industry self-regulation that will further determine this landscape of IPRs in a given company. Research and development must be sensitized to and be well attuned to work with the management and the IP department. This is something that management needs to, you know, to make happen. And one of the ways that is usually done is that you have some kind of invention detection and improvement program where you have a committee in a company or at a research institute where there would be 3 or 4 more experienced scientists of different technical background, a lawyer, an IP specialist, and someone from the management. And then they sit together and review the applications that they received from the inventors. But obviously inventors need to be sensitized to know that they have to apply for protection of their inventions. And they must know that some of the protectable inventions will not fall within the budget, because scientists are sometimes very disappointed. How did the institute decide to protect my colleague's invention and mine did not? So the rules must be very transparent in order to have a smooth effect of, collaboration between different inventors within a company. And that is what is meant by having a program, invention detection program. There needs to be some kind of marketing, and this applies also to inventions. So if you have some kind of a technology transfer office attached, not only this type of a committee that decides what will be protected, but there is it doesn't have to be 24/7, but if you have a 5 days a week, someone you can talk to, how to reach out to market your invention in the future, that is something very, very beneficial. And obviously, as I said already, in-house legal services must be involved, and it's good to have their lawyers who are experienced in working with engineers, because the languages are different, the cultures are different, and the lawyers are very often seen as someone who's only complicating, and they don't know how to explain what are the alternatives, and so it is also necessary to educate lawyers. They will not study at law schools protection of intellectual property. This is still, after so many decades of our ever more using of intellectual property protection systems, still it is not a mandatory course in most of the universities. So most law schools will have this as an elective course, and the lawyers will not know. So there will be a disadvantage, really, when they fall suddenly into this area and have to work with intellectual property. They will have to learn this almost from zero, So this is one of the difficulties. Then you need to have a company security functions made so that the inventions don't leak out, that they are not sold. We had in Croatia for a period of time a totally unregulated area, and a lot of those entrepreneurial scientists were just taking their own inventions as they were really their own, and as if their employer would not have had any rights over them, and were going commercial for their own account, rather than sharing this with the legal institution that partially, at least, or fully has financed this. So there's a lot of here areas. They are not gray areas. They're just dark areas in which there is no, and people take advantage of the absence of regulation in the situation, for instance, of transition as it was in Croatia. Now, this all over the last decade got much more regulated, and we also, in addition of that, have technology transfer offices, but showing how hard it is to run a successful technology transfer offices, that almost all Croatian first generation technology transfer offices failed and were reformed, and they started anew. So it's a big effort, and it's not easy to be successful and efficient in this area without really having some experience and like that. Again, here joining the European Union was decisive for Croatia in increasing the presence of intellectual property infrastructure. So this is just priceless, as they say in the credit card advertisement. Then there are other functions such as internal controlling that will check all the players in a corporation, all of those that I have mentioned. And then there's a knowledge of managing of external associates, such as lawyers or specialized representatives, because as many of you know, very often patent agents are really not lawyers, they are engineers. And as a rule, more developed a country is, more patent agents will be will be engineers and not lawyers. In the US, again, they have the best solution because of their educational system. They have lawyers with what they call technical background, meaning that they have they went through engineering college, and then they did the law school. So they are fully educated both in the field of engineering, being mechanical or electrical engineering, you know, or whatever, biotech, you know, and then they go through to the law school. Our system is not such, even after the Bologna reform, and we still lack people with double legal and technical backgrounds in Europe, all the bigger countries, and Italy here definitely is one, is a country belonging to this what I think of as bigger countries, is definitely has a number of engineers available to industry and science, incomparable, you know, to a smaller country such as whatever, you know, Slovenia, Bulgaria, or Croatia, or whoever. And just the fact that I am also a European patent agent without being, this is a system called grandfathering, where the countries that have joined the EU were granted the right that their patent agents locally became patent agents in the EU. Unlike most of these people, I don't have technical background, but at least in the US, I have studied patent drafting. But most other, my fellow grandfathers, you know, who were admitted to the European patent bar, are lawyers only, and they don't necessarily have experience or knowledge of patent drafting, no? So I have a theoretical thing, and over 30 years I have learned to work with inventors in any imaginable field. I'm working now on artificial intelligence patents and things like that, but it's always an uphill battle, a struggle to conquer the new technology for those of us who are not specialized. And if you have a country so small as Croatia, then you will never have number of agents to cover all the fields, technical fields that can be applied for patent. So, but even, you know, even in London and in Paris, you will have most of patent agents getting acquainted with the different technical fields during their career, and they will be drafting, you know, whatever as we do. Only we do it, you know, 3 times a year, and they do it 30 times a year, no, or even more, you know, as an individual. So that's managing specialized representatives. For instance, you need that kind of knowledge to understand who's who in the patent services industry. Then you have things such as watching services. This means that there are people who search the databases to find similar rights, be it trademarks or being patent searches. Which is such a huge field that I could speak, you know, an hour and a half only about the patent services, and then another hour and a half about other searching and watching services. So I'm not going into that, but just to understand the true complexity behind this and the knowledge that people who will be steering inventors in doing best kind of protection, they will need to have understanding of this thing. Then something that I have shared with you, intangible assets and IP awareness in the terms of being able to identify them. You know, you need to be identify them in time, not to stress your association. Now, if you are sleeping for 8 months of a year and then in the remaining 4 you want to protect the 3 patents, this is much bigger stress for your institution than every 3 months going into another patent, or every 4 months, you know. So this is something that needs to be a continuous and a systematic activity of picking up the things that will be protected. For this, you need education, training such as this one, you know, and collaboration between all. Because in spite of being so expensive, the advice from intellectual property specialists will in part be based on collaboration. So you will be able to receive a lot of information without paying, in a hope of setting things right. So when the protection is really sought, then this will be charged. But in between, you know, there will be a lot of explaining and information available that is not necessarily as expensive as, you know, as you can imagine, so as you would imagine. So it's less. Okay, now going into the particular rights. And I apologize, this mouse that I was showing is so sensitive that I barely touch it and the screen jumps. So sorry about this. Then look at copyright. So just for you to know, because modern IP is inherently inadequate, so it never fits perfectly. I mean, never, you know, in 50% of cases it fits, but increasingly it doesn't fit. Therefore, you cannot say, I am a scientist, I will work only with patents, because that's what protects my added value. In modern conditions, everyone actually needs to be at least aware of the other fields of IP protection. And among them, certainly one of those that costs less is copyright, or what we call in Europe, we call it author's rights. Autorska prava, diritti d'autore, no? And the related or neighboring rights, it's very often in English is used neighboring. So where you hear neighboring rights, that means related rights. And that is the copyright itself, which protects the works of literature, art, and science. So the part of science, I want you to understand that you cannot protect an invention by copyright, but an article will be protected by copyright, a scientific article. So it doesn't have to be an artistic, a novel, you know, in order to get copyright. Scientific writing will be protected, but the invention itself will not. And the discovery, if you have, or if you are so lucky that you have a revolutionary discovery, this will not be protectable either by copyright or by patents. And funny enough, you know, a lot of people who were in last 20 years complaining about IP being detrimental to our societies because you cannot share things, actually never fully appreciated the fact that IP system is made so to exclude protecting things such as business methods or discoveries, for instance. You know, you cannot protect them. They are prohibited from protection. You know? So I have paradoxically a situation in which I have inventors coming in, and they, until 2 years ago, they might have been, you know, opposing the IP, but then it happened that they developed some invention that seems valuable to them, and they changed their mind, and now they go out of my office being disappointed. How little can they protect? But before they thought there's too much protection. So this feeling of what is protectable, we all need to share in modern society. And one of the differences between copyright and industrial rights is really that what you protect by copyright is expression. It's not what you have discovered or what you have invented. It's how you wrote about it. So this is not an adequate protection for industrial exploitation. It protects you only from someone plagiarizing your article, you know. So not what is the underlying invention. So that's an important understanding, which is on the basic level something that we all need. And then you have related rights such as performing artists' rights. So the performing artists' rights are the biggest group of rights between these neighboring or related rights. And let me just also say, you know, we often describe copyrights as kind of a bunch of rights. So copyright is not one right. It's actually bunch of bunches. You know, there are several bunches tied together, and the copyright itself will have at least two big bunches, and that's moral rights that you have heard about, and the economic rights over a work of art, because what is protected is called work of art. Then, so this one bunch has two big bunches, and then these two smaller bunches will have at least, you know, like 5 or 6 rights each. Further, same thing with the related rights. You have performing rights, and then the rights of the manufacturer of phonograms, videogram manufacturers, broadcasting organizations, publishers, database manufacturers, and each of these smaller bunches within the related rights bunch will have its own rights again within the bunch. So that's the way of understanding how these things work. And what is so convenient there is that it's not a registration right. You don't go to a patent office to obtain copyright. Copyright, as they say traditionally, follows the pencil. You know, when the poet was writing a poem, as he wrote it, unless he was copying, he got the copyright protection. And the same thing today, when you design a website, the layout, the graphical layout, or the choice of the combination of colors that you made will be protected. You don't have to go anywhere to ask for a registration. There are countries, again, such as Italy, where the deposit was traditionally possible, so you could deposit the right, but it was not a condition for protection. And in Croatia, there were private deposit agencies such as Autorska Agencija and things others. You know, you can do that with the notary public. You can go and deposit individually your right, and you will get a date. As you can see, the date is part of so-called copyright notice. So you get the date when you deposit it, but you don't have to. It's enough that you put the copyright notice on your work. So you put the C encircled, you know, as a sign. You put the year when the work was done, and you put the first and the last name of author or a name of the company if it was transferred to a company. And with that copyright notice, you have a presumption of right on that work of art. And if it is indeed original, then you have the original means subjectively new. So originality in legal sense is not probably identical to originality in history of art, but obviously they derive from the same concept. But if you look in copyright legal terminology, this means subjective novelty. So if you haven't seen before or heard that work that your work of art is similar to, then you still have the right. This is not the case in patents, where you have objective novelty. This is why they are examined, and there, even if you came independently to your invention, if you were not the first, you will not have the right. So that's the difference, how it works. Then we have a problem of functionality, and for instance, here we had a very big difference exactly between Italy and Croatia. Italy excluded protection of functional aspect of a shape very strongly, traditionally. And one of the reasons was because of the strong furniture industry wanted to produce replicas early on. So since the 50s, the copyright was always not giving protection, for instance, to the classical Nordic design or something. And because it was considered that the chairs would be functional and that the form was dictated by function. In Croatia, this was not. And we went to the other extreme in Yugoslavia, probably even because of the lack of knowledge. But we had situations in which, for instance, a court in Osijek in the 80s gave a copyright on a newly developed wheat seed. So actually a plant variety, to a scientist. I mean, I don't know the details of that case, so I'm not going to be able to explain you what happened there. But this is something that will not happen in another country. But in Croatia, for the first 15 years almost, until our reform of copyright in 2003, when we started getting the EU, you know, we had this We Protect Applied Arts, you know, in Croatia, which in many countries are not. And you need to know that what the culture around you tells you, you can rely on copyright in Croatia. It will not be like that in other countries. And in Italy, it is very restricted, because whatever has an element of functionality, and again, I have to apologize because I don't know how Italy reformed its copyright over the last 10 years. And I don't know what happened with this functionality exclusion. Really here, Italy was, you know, going to go closer to European standards. Paradoxically, this is strong also in common law countries, meaning in the US and in the UK. And UK also had the same thing with furniture when they were in the EU as well. Also the other benefit is long duration of protection and a relatively low cost. You know, in intellectual property, all advice is complex, expensive, and with the copyright, again, you have national jurisdictions. You will need to ask, how is it in Italy, or how is it in Germany, or how is it in Switzerland, before you go. And it always becomes, so even something that costs much less than a patent will be only relatively low cost. And then the other huge batch is the industrial property rights, where we have much more different rights than within copyright and related rights. And that's, we have trademark, which is marchio in Italian and žig in Croatian, which is a sign showing the origin of goods and services. Then we have industrial design, which has kind of a universal name in the EU, which protects 2 and 3D shapes. Then we have patents, but patents are also a family of different rights, and you will have the normal patent that we all think of when we say patent, but you will have a different kind of small patents, such as utility model that is in Croatia. I forgot what's the situation in Italy. In Germans call this Gebrauchsmuster, Australians call it petty patent, and so on. You know, there are different small patent varietals around the world. Then both of our countries hugely use geographical indications and all types of indications of origin. And I, as someone who lived in both countries, I can tell you that it's really similar. You know, you go 50 kilometers and you have different ingredients, different food, different, you know. So that's something that is very important for us. And within the EU, all southern European countries use it much more than northern because of the, you know, very rich food and wine sources and number of varietals that are autochthonous and so on. So that's important for us. Then there's topography for semiconductor products. That's something that's rarely used in Croatia, but it has been used in the meantime. Before, you know, 5 years ago, I was saying it was never used in Croatia. This is not true anymore. It was used. It's a we will not devote any time to that. There is plant species, the so-called UPOV convention when you hear. So I don't think it covers any type of marine new species. But I actually don't know. I never thought about it even when I was preparing this. I didn't think. But now, as I'm talking to you, I'm thinking about the marine things. I don't think there are named varietals that can be protected. So I don't think it applies on any you know, species that would be developed, but that might be an interesting, you know, discussion. Probably someone of you would know if this is possible or not. And then there are business secrets and so on. So actually we are, I think, somewhat ahead of time, and I will be able to have your questions. I would prefer that. If you don't want to give me questions, then I will go until 12 with what we have tomorrow, what was planned for tomorrow. But if you do have questions, I am most happy to devote all 10 minutes to discussion.
No questions on my side.
But there must be some questions from someone. Thank you for letting me know that it was, I hope it was clear, you know, and that you could benefit it as such. But I would expect that there would be some incomprehension, you know. Also, I loaded so much.
Everything was clear. I gave for assume, let's say, that legislations were more homogeneous across Europe, but as far as I understood, that's not the case.
This depends on which right. The trademark right is much more homogeneous than copyright. Copyright had a very gradual harmonization because part of it does not fall under the European treaties. So the EU Commission didn't have initially right to harmonize copyright to the same degree as it had for the industrial rights. This was later changed, and it's still changing, but that's one of the reasons. So copyright is less. Also criminal law, for instance, you know, and tax law, it's the same thing, you know. It is not harmonized across the EU because this was not in the Rome Treaty, not in the Maastricht Treaty, and so on. That's the reason. But copyright is now considered to be important for the common market, for the commerce that we have on the common market. And I don't even know at this moment what was the legal switch. At which point did the Commission start? This is a DG Connect, is the one that has many aspects of copyright, and not only DG Trade, for instance, but when you think about the criminal protection of copyright, for instance, some countries will have it much stronger than the others, you know, so it will be uneven. But the EU Commission has no authority, because this is criminal law, you know, and it is not in the treaty. So that's the reason. No. So just to finish with one thing, for instance, so we have an enforcement directive for trademarks, where we tried to harmonize the ways of how will, you know, police act in respect of trademark infringement, and what can you sue for, what can you claim in courts. But this did not include criminal enforcement. And when they started drafting the criminal enforcement directive, which exists as a draft, the member states said, no, you don't go into this. This is criminal law, and we want to have separate criminal laws. And this is this is not a devolved jurisdiction to Brussels. So we have unharmonized criminal law protection. Any other question or doubts or experiences? If you have more experience, you know, with IP or how it works with the technology transfer offices, I would be interested to hear, you know, do your institutions in Croatia and in Italy have in technology transfer offices, and how do you work with them?
Well, we have one at University of Trieste, for example, but we don't work too much, only when it is needed, and especially our art sciences scientists. I'm not in art sciences, that when they have patent-related issues or copyright-related issues, that work with the office, but actually is not continuous, and also there is no let's say continuous education on the topics. That's why I was interested in.
Okay. I would I'm, you know, I hope then that my contribution is valuable to you in light of that you don't have this on the permanent basis. But let me ask you, is that the behind of you is the building of the University of Trieste, isn't it?
Yes, exactly, the main building, but of course it's a fake. I'm not in the middle of the street.
Yes. I know Trieste also very, very well. As you know, in Trieste, we go for a lunch to Trieste, and from Zagreb is only 200 kilometers. So
yeah.
Often there. Any other experience with the technology transfer on the other institutions? No. How about, I didn't hear my fellow Croatians at all. I mean, do you, did I presume correctly that some of you will be in Split or Rovinj and some in Zagreb? I just was thinking about, you know, Ruđer Institute and the Split Marine Institute, which I see from my porch here, and I see the Bios 2 boat sailing out of Split all the time now. And am I right in thinking that there might be someone from here?
Croatian Chamber of Economy, our partners from Institute Ruđer Bošković are not here now, so maybe that's why they're not dating.
Okay. And do we have anyone from Split, marine biology or whatever, in the project at all? No.
No, no, we do not have. They are not our partner in this project.
Okay. Good. Okay, so is there, just to conclude then, was there something surprising for you, something that you thought is unexpected today that you want to comment?
I just have a small comment from my side that is not something unexpected that I've heard, but something that we face in our offices is that many cases companies come to us when they have a problem. So it is clear that when we talk about strategy, IP strategy, there is a lot to do.
Thank you for mentioning. I totally agree. You know, I have, by the end of the 90s, that's when I understood that without strategy, none of these transitional companies that we had in Croatia will ever get anywhere. And it took them another 10 years for them to start realizing this in a small number. And Italy, being much bigger economy and much bigger country, it's a very strange situation because it has a world-class, you know, top-level outfits that totally perform like, let's say, in the US, you know, but that's just because of my experience. But at the same time, has these problems that are not really, but almost as in Croatia. So there's a very big, you know, depth in this knowledge, how it is in Italy. So I would imagine, you know, I work with a lot of Italian patent firms, a lot, you know, I'm probably 60% of all, because of our connection to Italy. So I was even thinking of somehow offering services that we were able to perform for past decades for lower, you know. And obviously, you know, when you have someone who studied in the US and worked in Italy, I can give quite a good added value, but probably for a lower price. So we were talking to people, I don't know if you know these guys from Friuli, GLP, for instance, and things like that, you know, about making some kind of a joint programs. This never happened in the end because also we were not in the EU at the time and so on. But there is a space, as you have pointed now, in Italy, which I also have seen, you know, that can be developed.
I think that there are two aspects to take in mind. That from one side, most of our companies are very small. The 90-95% of our companies in Italy are small. So maybe there are not enough resources to manage in a way of a strategy, the IP issue, I think. And from the other side, even if there are some companies, small companies that pay attention to the topic, maybe they do it. As I'm gonna say, I make an example. I have my trademark, and that's it. They don't do anything to manage this this trademark. So many cases they register, they have a trademark, but they do not do anything to protect it, to exploit it. Okay.
Yes. You know, if you want to hear frankly, I mean, I have a lot of also Italian clients, not also through my correspondence in Italy with whom I work in such a great number. And also we have a number of Italian cases. I had the cases where people within the company were unprepared in the level that they didn't understand geography, you know, and you have to understand geography if you go for territorial rights, you know. So So it's I was really surprised, you know, the big brand, you know, very successful company with a nice portfolio, but then not finding their way really to efficient enforcement, you know, things like that. So yes, there are problems, and this is not only problem to Italy or Croatia, because we have a set of similar and set of dissimilar problems. One being, you know, the availability of capital. In Croatia, you couldn't get capital in the past. Now this is also changing, but in Italy, you could get access to capital easily. But we had this similar, you know, there was some kind of overlap. But the problem with small company is a European-wide problem. SMEs are, as we all repeat all the time, backbone of the European economy. We are not good at creating large companies like Americans or Chinese, you know. We live from making strong these small companies, and they are not ideal users of intellectual property system, you know. And I think, and I will conclude with that because we are a couple of minutes beyond time, although if you want to ask me anything, I can stay. But in Europe, we must make system more friendly, or even if we can't make the system, because this will require multilateral effort. We will have to work with other countries in the world to create a improved IP system. But for Europe, actually, in my view, does not speak enough about the difficulty of small users using this complex system, and the advantage that the big users have over the small in using it. So that's my 2 cents about one general European problem. Okay. If no further questions, then I especially am mindful about our Italian participants' lunchtime that always starts earlier than in Croatia. So have a buon appetito and enjoy. I'll see you tomorrow at 10.
Thank you very much.
Thank you.
Thank you very much. See you tomorrow.
See you tomorrow. Thank you. Bye-bye.
See you tomorrow.
Thank you. Bye. Thank you. Bye-bye. Bye-bye.
Bye bye. Thank you. Bye.
Bye bye. See you. Thank you.